Holmes is present with his attorneys, and the prosecutors are present as well. We are outside the presence of the jury at this time. I show that we have three issues tabled for today. One has to do with the victim impact videos that were the subject of motion D-288, which I struck. Next is the jail records. And then finally, we have the pregnancy issue and the admissibility of evidence related to Ms. Mosher Sullivan's pregnancy and determination of that pregnancy as a result of the shooting. So let's take up the victim impact videos first. Ms. Nelson?
Your Honor, I first just wanted to clarify the status of the record. I don't know what the court, when the court is striking pleadings, is the court still keeping them in the court file? And if not, we would request the court do so and just mark it like a tendered and rejected exhibit or instruction.
It is part of the court file, and I think I indicated that in a footnote, that it's part of the court file, but I'm not considering it because it's been rejected. So you can make your argument here today, and if it's okay with you, I would like to review the videos that are in question. I think you had submitted them with your motion, and so I think we still have them, or if you want to tender them as exhibits, we can proceed in that fashion too.
I did make, out of an abundance of caution, another copy because I wasn't sure what the status of those videos were since the pleading was stricken. So I gave a copy of the CD to the prosecution during the break, if I may approach.
Yes, I think that's the best way to proceed. Any objection from the people?
No, Your Honor.
All right, thank you. Thank you for doing that. How many videos are there, Ms. Nelson?
They are exhibits A through H, so however many.
8?
8.
Okay.
Your Honor, our first argument with respect to the videos is that they were disclosed to us in an untimely manner. The prosecution endorsed victim impact witnesses in P-83, which was filed on June 14th, 2014, and we did not receive any notice that they were, in that pleading, that they were intending to introduce these videos at sentencing until after the start of jury selection. Some of the videos were given to us in February, and the others were given to us in April, several days before the conclusion of individual voir dire. And so we would move to exclude them based on Rule 32.1D3.
Which ones were provided in February and which ones were provided in April?
So, one moment, if I may have a moment.
Yes.
And Exhibit D, which were contained on CDs 377 and 378, were provided to us on February 5th. Exhibit E and Exhibit F, I show we received on February 27th. And then Exhibit G and Exhibit H were provided to us on April 6th.
Okay, thank you. Before I forget, do the people have any objection to me reviewing these videos?
No, Your Honor.
All right. Ms. Nelson, go ahead. Your first argument is the untimeliness of the videos.
Yes, Your Honor.
What's your second argument?
Our second argument is that the videos contain, a number of the videos contain inadmissible hearsay. In in Order P-109, the court ruled that the rules of evidence apply in a capital sentencing proceeding and excluded a number of the defense's tendered videos on this basis. And so the same rule we submit must, of course, apply to the prosecution's videos as well. I would note, and Ms. Teach-McGuire can address this, that during the break I learned that the prosecution, she's intending to do some redactions to the videos, addressing some of the issues that I plan to raise with the court. So I won't spend significant amount of time discussing those. But the redactions don't address all of the hearsay issues that we have with the videos. Exhibit B, which is a video of deceased victims' loved ones discussing the impact of the loved one's passing, consists almost entirely of hearsay. It's a very similar argument to the argument that the prosecution made with respect to some of the mitigation videos that we submitted. And those statements are being offered, we presume, for the truth of the matter that they assert, and should be excluded under 801 and 802. The same argument applies to Exhibit F, which consists entirely of hearsay. And there are some exhibits C and D and H contain song lyrics and music, and the prosecution has indicated that they will redact the music, but we, just for the record, object on hearsay grounds with respect to the music and the song lyrics for the same reasons that the court excluded the music from our videos. And there are also some words on a screen in Exhibit H that appear to be a poem of some sort. The prosecution, my understanding, is also going to redact those as well. And the same applies to Exhibit A and G to the extent that any of the words that are spoken on those videos are offered for the truth of the matter asserted. And I'd just like to make a record that the admission of any hearsay testimony in these videos would not only violate the prohibition against hearsay, but would violate Mr. Holmes' state and federal constitutional rights to confrontation, due process, and a fair and reliable sentencing proceeding, as Mr. Holmes would have no ability to confront or rebut the testimony and statements contained in these videos. And we cite to Crawford v. Washington, 541 U.S. 36, 2004, Gardner v. Florida, 430 U.S. 349, 1977, which held that the petitioner was denied due process of law when the death sentence was imposed, at least in part, on the basis of information which he had no opportunity to deny or explain.
What was the last case? Gardner
versus Florida.
Thank you.
United States versus Brown, 441 F. 3rd, 1330, an 11th Circuit case from 2006, explaining that the Confrontation Clause applies at capital sentencing. And People versus Walters, 821 P. 2nd, 887, a Colorado Court of Appeals case from 1991, as well as the U.S. Constitutional Amendments 5, 6, 8, 14, and the Colorado Constitution, Article 2, Section 16, 20, 23, and 25. Our next argument is that some of the videos contain footage that is irrelevant to any material issue at sentencing. Exhibit A contains some footage at the conclusion of the video. Well, first we would submit that Exhibit A does not appear to be probative of anything that is relevant in a capital sentencing hearing, but it also contains a portion of a video of an individual who is not the deceased victim in the case dancing to a song. So that is clearly irrelevant to any issue in a capital sentencing proceeding in this case. Exhibits E and F we submit are not probative of this deceased victim's personal characteristics or the impact of the crime on his family. And in Exhibit G is another one that my understanding is the prosecution is going to redact. It's an hour-long video of Ms. Mosher Sullivan opening Christmas presents, and there are portions of that video that we submit are clearly irrelevant, but I won't make any additional arguments on that point until I see the redacted video. Third, and this is a global objection to all of the videos should be excluded pursuant to Colorado Rule of Evidence 403, as well as Mr. Holmes' state and federal constitutional rights to due process, fundamental fairness, a fair and impartial jury and a fair and reliable sentencing proceeding because they have the potential to cause unfair prejudice or arouse undue sympathy, which may overwhelm the proceedings with emotion. And we cite Payne versus Tennessee, People versus District Court, which is 834 P. 2nd 181, a Colorado case from Supreme Court case from 1992. People versus Tennyson, 788 P. 2nd 786, Colorado Supreme Court 1990, as well as the U.S. Constitutional Amendments 5, 6, 8, and 14, as well as Colorado Constitution Article 2, Sections 16, 20, 23, and 25. And we also incorporate by reference all points and authorities cited in Motion D-166. While the defense objects to all of the videos in their exhibits C, D, and H, which are photo montages set to music, have a particular potential to violate Mr. Holmes's rights to due process in Rule 403. A number of courts have expressly disfavored victim impact videos that were produced for a memorial service contain lengthy photo montages, including photographs of adult victims as children, or are accompanied by evocative music. And we understand that they're willing to redact the music, but we still have remaining objections about the rest of the videos. I would say to State versus Hess, 23 Atlantic 3rd, 373. A New Jersey Supreme Court case from 2011. United States versus Sampson, 335, F sub 2nd, 166. A federal case from the District of Massachusetts in 2004. Salazar versus State, 118 Southwest 3rd, 880. A Texas Court of Appeals case from 2003. And our final argument is that the videos are likely, although we understand the court can't make a cumulative determination until other evidence in the case is admitted, but we would note that the videos are likely to be cumulative in some fashion to the anticipated testimony based on what was disclosed in P83. And we would cite Colorado Rule of Evidence 403. And for the foregoing reasons, the defense respectfully requests that the court issue an order precluding the introduction of these videos into evidence at any sentencing hearing in the case. And we would note that we do not object, Your Honor, to the prosecution playing these videos for the court when Mr. Holmes is formally sentenced following the jury's verdict in this case. But we do object to them being played at a sentencing hearing before the jury.
All right, thank you. Ms. Tisch-McGuire, are you going to respond?
Thank you. Your Honor, first, if I could address the defense's untimeliness argument. The prosecution did not become into receipt of any of these videos until the date they were discovered to the defense. What happened, frankly, is that, it's difficult for victims' family members to want to try to find these things. And so as soon as the victims' family members found the videos and tendered them to the prosecution, we turned them over to the defense in their entirety at that point in time. I'll note that, particularly the victim impact video from Veronica Mosier-Sullivan, her grandfather didn't even know the video existed and that he still had it. All the other videos that he had were stolen from his house shortly after July 20th of 2012. And then he luckily happened upon this one video of Veronica and then contacted me when he did. Additionally, the prosecution didn't receive the defense disclosures from what they intended to admit during the sentencing phase. And at that time, the prosecution became aware that the defense intended to introduce several videos of the defendant, and from the defendant's childhood, other times of the defendant's life. And so, frankly, we think that justice due to the accused is due to the accuser also, and believe that it would be important that since the defendant gets to be alive in this courtroom today, the victims who don't have that opportunity could have their videos shown in the courtroom. Additionally, the people would note, while it's certainly, the people want to tender this discovery to the defense as soon as possible, obviously the defense we still tendered all of this evidence way before the prosecution became into receipt of Dr. Woodcock's report, which the court knows was extremely late. And also, we would just note that the prosecution would, Your Honor, like to redact these videos, and the prosecution only has videos from 4 of the 12 deceased victims. That's all we intend to introduce at the sentencing phase, and with the court's permission, I would like to tender the redacted portions of these videos by noon tomorrow. We apologize, but our paralegal became ill this week, and so if we could, with the court's permission, have until noon tomorrow to tender those videos, we'd appreciate it.
Okay.
Additionally, Your Honor, in terms of their argument about inadmissible hearsay, the prosecution is certainly not offering any of the voices that would be heard on the videos for the truth of the matter asserted. Rather, it would be to try to show the personality of these victims while they were still alive. And the prosecution would agree to redact any music and also poems or words other than, the words of our victims or the words that may be on a tombstone from the exhibits that we would introduce. In terms of their argument that the video is irrelevant, frankly, that victim impact video is about Jessica Gowie, and she dreamed of being a hockey player news correspondent, and that's what that video depicts. It's her interviewing a hockey player. So we couldn't find a way that it would be more probative or more relevant of her life. The prosecution agrees with the defense that we do not need to play the last part of that portion of that video that's just of the hockey player and not of Miss Gowie. So we would agree to that redaction as well. And then in terms of their argument that the 403 argument, this is not a case where the probative value is substantially outweighed by the danger of unfair prejudice. This is a sentencing hearing, and the purpose of victim impact evidence, it's relevant to the jury's decision as to whether or not the death penalty should be imposed. It demonstrates the loss to the victim's family and to society, which has resulted from the victim's homicide, which is from Payne v. Tennessee 501 U.S. 808 at 827, 1991. And then in terms of the defense's argument that this evidence would be cumulative, frankly, videos that depict living victims is absolutely not cumulative of testimony of their parents speaking about the great losses to their families. And so we would ask that the court consider that as well. And then finally, Your Honor, I would like to cite to the court several cases which I think may help the court with these determinations. One is People v. Kelly, which is 171 P. 3rd 548, which is a California Supreme Court case from 2007. In that case, the California Supreme Court heard that a jury who watched a 20-minute video tribute of a young woman who had been raped, robbed, and murdered by her personal trainer. The video was narrated by the girl's adoptive mother and included stock footage and songs by singer-songwriter Enya. And the Supreme Court upheld the admission of that video. Also, People v. Zamudio, which is Z-A-M-U-D-I-O, and that is another California Supreme Court case from 2008, 181 P. 3rd 105. In that case, the jury viewed a 14-minute montage of still photographs of 79 and 74-year-old victims who were murdered by their neighbor and narrated by the victims' children. It portrayed the victims from early on in their childhood, shortly before their deaths. I'd also cite to the court State v. Allen, which is 994 P. 2nd 728 at 751, which is a New Mexico Supreme Court case from 1999, which featured a 3-minute video clip of teenage female victim on a camping trip with her friends. I would cite to the court People v. Bramit, which is B-R-A-M-I-T, 46 California 4th 1221 at 1240, which is a California Supreme Court case from 2009, which is a 3-minute photo montage of an adult male victim's humble beginnings in New Mexico. I would cite to the court State v. Gray, 887 Southwest 2nd 369 at 389, which is a Missouri Supreme Court case from 1994, which allowed a home video of brief but unknown length showing young murdered sisters celebrating the Christmas holiday with their family members. I would cite to the court People v. Brady, 236 P. 3rd, 312 at 337, which is California Supreme Court case from 2010, which is a 4-minute home video of a police officer enjoying the same holiday with his family shortly before his death. I would cite to the court State v. Bixby, Bixby, which is 698 Southeast 2nd, 572, which is a South Carolina Supreme Court case from 2010, and the court held that the probative value of the videotape showing portions of one victim's funeral was not outweighed by the danger of unfair prejudice at the sentencing phase, and that the evidence was victim impact evidence that showed the trappings of a funeral demonstrating the general loss suffered by society. I would also state to the court Whitsley v. State, which is Whittlesey v. State, 665 A. 2nd, 223 at 250 and 251, which is a Maryland Supreme Court case from 1994, which in that one includes a 90-second clip of a victim playing a piano used to demonstrate that they were an accomplished musician. There's also State v. Leon, 132 P. 3rd, 462, and that's 464 through 468, which is an Idaho Court of Appeals case from 2006, which also included video montages. And then I would cite to the court United States v. Wilson, which is 493 F. Sup. 2nd, 491, 505, which is an Eastern District of New York case from 2007. And that impact video was a 20-minute television interview with a deceased policeman discussing the hazards of his undercover work. Also, People v. Prince, which is 156 P. 3rd, 1015 at 1091, which is a California Supreme Court case from 2007, which is a 25-minute interview with a high school student who was profiled by a local television station before they were murdered. And then I would also cite to the court Hicks v. State, which is 940 Southwest 2nd, 855, 856, which is Arkansas Supreme Court case from 1997, which is a 14-minute video that was played to the jury. Thank you, Your Honor.
So, Ms. Tisch-McGuire, you're not contesting that the rules of hearsay apply in a sentencing hearing. You're not changing your position on that. Is that correct?
That's correct, Your Honor. So I'm just saying that we wouldn't be offering the statements for the truth of the matter asserted.
And so, as you heard, part of the argument that Ms. Nelson made was, I had ruled before that some videos that defense wanted to introduce were not admissible in a sentencing hearing because I agreed with the prosecution's position that hearsay is not admissible, and the hearsay rule applies in a sentencing hearing just as much as it applies in a trial, with some exceptions, some constitutional rare exceptions, or with some exceptions to the hearsay rule, which we're all familiar with. And so you're saying these videos are not being offered for the truth of the matter asserted.
The statements made in the videos are not being, offered for the truth of the matter. We're just trying to show the personality of the victims.
And so that you're distinguishing these videos from the videos that were excluded by the court in the motion that was filed by the defense?
And I am, Your Honor, because in those videos, those were people who were familiar with the defendant, who were trying to offer their statements for the truth of the matter asserted about, to influence the jury at the victim impact stage. And our point is to not do that. It's just to show the personality of victims who can't testify because they're no longer alive.
Okay. All right. Ms. Nelson, how are these different from the home videos that you want to introduce with respect to your client? In terms of the hearsay objection, how are these different than the home videos that you want to introduce with respect to your client?
Well, we're not necessarily introducing the home videos for the truth of the matter asserted either. But I would note that not all of the videos that they're attempting to introduce are home videos of living victims. There is, at least one of the exhibits is a video of two surviving family members and loved ones discussing the victim. And that's very similar to the videos of mitigation witnesses that the defense concluded are inadmissible. And I do just in response briefly to the other arguments.
Hold on, before we move on. Ms. Tisch-McGuire, are you intending to redact that portion?
Yeah, Your Honor, we do not intend to introduce that. I'm sorry, I meant to clarify that.
Okay, so let's set that aside for a moment because they're apparently going to redact that. So they're not intending to introduce that. So assuming that we don't have statements like that and we have the videos, the rest of the videos or the rest of the videotaped material, how is it different or is it different than the types of videos you're intending to introduce? Just for purposes of hearsay.
Well, Your Honor, hearsay covers, prohibits statements, out-of-court statements that are offered for the truth of the matter asserted. So we aren't asserting, I have to be honest, off the top of my head, can't think of all of the videos that we're intending to introduce, but I don't think that those would be offered for the truth of the matter asserted, so. I mean, we've made the argument about the hearsay with respect to their videos. If they're not offering it for the truth of the matter asserted, then it has to be admissible for some other purpose. That's my argument on that.
Okay.
And I just want to make clear, Your Honor, with respect to the timeliness issues and the argument that, well, we're submitting these videos and so they're submitting these, now they're going to submit these videos too, is that the definition of mitigation under the law and under U.S. Supreme Court case law and the definition of victim impact evidence is different. The Constitution requires and specifies that the background and character of the defendant, as well as anything that the jury, that may cause a juror to consider a life sentence over a death sentence, is constitutionally admissible mitigation. And so I wanted to make sure that I made the point that the definition of mitigation and the definition of victim impact evidence is not the same. And with respect to that argument as well, I don't think these victim impact videos could constitute rebuttal evidence to our mitigation videos in any way, shape, or form. And so the fact that we decided to, they made their decisions about what they were going to endorse in P83, and we made our decisions about what we were going to endorse in our disclosures under 32.1. And so that doesn't excuse the untimeliness.
Okay. All right, let's move on. Should we move on to the jail records? Yes, okay. Who wants to go first?
Your Honor, I will. I considered the court's suggestion that at some point we're able to get a list of people and provide that to the defense, and I understand where the court's going with that. Respectfully, I'd suggest we sort of do it in the opposite way for this reason. I can't know who has come and visit him in the jail that may be someone we're not aware of, that we would like to be aware of. And I can't know everyone that has gone out there that may have a privilege attached. So what I would respectfully suggest is that instead that list, that log, be provided to the court and to defense counsel, and that they be given a time that they go through and they strike who they believe they have a privilege to keep us from finding out about, which I totally respect. And then we would get the remaining list of names and we'd be able to do our due diligence about who's had contact with the defendant that we didn't know about beforehand, or even be able to check them against things they've said previously.
Okay. Who wants to address this on behalf of the defense? If you would go to the podium, please, or use the mic at the table, either way.
Sure. What does the court want me to? Does the court want me to address what Mr. Brockler just said, or does the court want me to address the entire issue, or?
Both.
Well, with regard to what Mr. Brockler said, I think that the end of that procedure would result in a list of 0, because we're asserting that everything that's on that list is protected by attorney-client privilege, with the exception, perhaps, if the court found this to be the case, of visitation by mental health professionals who have been endorsed to render opinions about sanity. And so with regard to those visitations, as I previously indicated to the court, those have all been provided to the prosecution. They know when each one of our professionals has visited, what date they visited, how long they were there, They have the notes of each individual visit from every one of our doctors who went in and conducted these evaluations. As such, I see absolutely no reason why they need to receive the same information, identical information from a secondary source when we run the risk that our attorney-client privilege might be impinged. So our position is that we rest on the original pleading that we filed and the order that's before this court that precludes their access to these records, and we object to them obtaining the records.
Does anybody have any authority on whether jail visit logs are privileged? Seems to me that's what's at the heart of the matter. I mean, either these records are privileged or they're not, and if they're privileged, then they're entitled to protect that privilege, and if they're not, then the people may be entitled to the information.
Your Honor, I don't have any record at all that would suggest that they are de facto privilege or presumed privilege in the absence of some other attorney-client relationship, and it seems like that party asserting the privilege would have to come up with that support. If the court would permit me to sort of respond a bit to Mr. King's point, to some extent what we're hearing, and I think Mr. Orman addressed this in the last time we started talking about this, was the idea that they've told us the things that they think that we're entitled to know, and that should be good enough for us. That's not a standard for anything, Judge. There's no protection here for them to meet. I'll give the court another couple examples. We've become aware of the fact that the Sheriff's Department, the Sheriff's Office, instituted a special procedure for Mr. Holmes to meet with his parents outside of the normal requirements of having those conversations videotaped the way we would do anyone else that comes into the jail to meet with them. Well, we're entitled to know when and for how long the parents met with them. The fact that even if defense counsel had been with the parents can't transform that meeting into a privileged meeting. In fact, it would violate the privilege to have someone there who's not part of that relationship. But there are other things like that that we should be entitled to explore. And so the idea that, hey, we're just going to say anybody and everybody that's ever met with our client is part of this 1390, 100 at sec privilege, Judge, that's just not good faith, and that's not accurate. We're entitled to check who's met with him against the other records that we have. We shouldn't have to rely on what the defense is willing to tell us outside of privilege. Thank you.
All right, and Mr. King, you're not just objecting to the disclosure of records that show visits by you or one of your colleagues, but anyone who's not an expert, right? Anyone who's not an expert on the issue of sanity.
Well, and this is what we were worried about, Judge, is this started out as a request for the visitation of the medical professionals. And now it turns out what they're actually looking for is the visitation of Mr. Holmes' parents. So we're claiming that attorney-client privilege would apply to every visitation when we as attorneys were present in the jail. And I can tell the court that every time his parents have visited, well, there have been attorneys from the defense present.
All right. Does anybody have any authority for the court on this issue?
I do not, Judge, have any specific authority on whether attorney-client privilege pertains to jail records, but my argument would certainly be that given the fact that there are attorneys visiting the client, that attorney-client privilege is implicated.
Even if there's a third party present?
Even if there's a third party present, Judge, this isn't a situation where we're, divulging information in a public scenario or anything like that. This is a confidential visitation in the jail.
Okay, well, I guess I'll take it under advisement. I mean, nobody's providing authority. I'll have to research it and see what I come up with. So it seems clear to me that at a minimum, the prosecution is entitled to know the experts who have been retained for purposes of opining on the issue of sanity. I mean, the defense has indicated that has been provided already. If it's been provided, the privilege, to the extent that there is a privilege, has been waived. If there is a privilege, I don't even know if there would be a privilege with respect to experts. And the question is whether the rest of the records are protected by some type of privilege or not, and whether the records are protected to include if one of the attorneys was present when one of the experts was present. Would that require some kind of redaction so that it would not be disclosed? And since neither side is providing any authority, I'll have to look into it and see what I can find out. So let's, yeah.
I'm sorry to interject, but if I may provide the court with an authority.
Sure.
And one additional.
Yes.
I just wanted to make the point that Mr. Holmes, this is a capital case, and Mr. Holmes' parents are witnesses, endorsed witnesses by the defense for the sentencing portion of this trial in the event that there is a sentencing portion of the case. And I would cite to Hutchinson versus People, 742 P. 2nd, 875, Colorado Supreme Court, 1987, in which the Colorado Supreme Court held to safeguard the defense attorney's ability to provide the effective assistance guaranteed by these constitutional provisions. It is essential that he be permitted full investigative latitude in developing a meritorious defense on his client's behalf. This latitude will be circumscribed if defense counsel must risk a potentially crippling revelation to the state of information discovered in the course of investigation which he chooses not to use at trial.
I'm familiar with Hutchinson, but Hutchinson is not on point. I mean, Hutchinson is talking about information that is discovered during the course of an investigation. We're not talking about the contents of any visits. We're talking about a log that shows who visited. It's not what was said, it's whether anyone visited or not. And so I know that Hutchinson was one of the cases you cited in your motion to the court before Judge Sylvester, my predecessor, entered the ex parte order, but I think Hutchinson is different. I don't think Hutchinson is particularly helpful. So again, I'll look into it and see if I can come up with any authority. Let's move on to the last issue, and that is the pregnancy issue. So who wants to go first?
I can again, Your Honor. And I actually have some supplemental argument and authority I'd like to make with respect to the two arguments we made yesterday as well, yesterday afternoon after the lunch break.
On what issue? On this pregnancy issue?
Oh, on the issue with respect to the motions in limine that we raised with respect to the medical treatment of the surviving victim's injuries, as well as the issue pertaining to victims testifying at this point to evidence that is undisputed and cumulative. I found some additional authority, and I had the opportunity to review the prosecution's authority that they cited in open court. So
I haven't had that chance yet, so I need to do that. If you want to cite additional authority, I'll take that.
very well, I can do that last thing, or I can address the issue of the pregnancies and the miscarriages now.
What's the additional authority on the other issue?
Well, Your Honor, yesterday, Mr. Orman made a statement that was along the lines of, this thing that they're not disputing anything. I've never heard of a case discussing this. If they're disputing something, if they're not disputing something, they can plead guilty.
Hold on, let me just stop you. I just need the additional authority
Well-
because I haven't read it yet. So let me do that. I'm not intending to take additional argument at this point. I just want whatever additional authority you want me to review.
Your Honor, I'm providing context for the authority that I'm citing.
Okay.
The context is that in response to Mr. Orman's argument, I said to the court that the fact that this testimony and this evidence is undisputed is relevant or bears upon the 401, 403 analysis. That was my response to Mr. Orman's argument. And I uncovered some case law supporting that position that I would like to cite to the court.
Okay, what's that case law?
There are a number of cases that discuss the fact that whether or not evidence is disputed or not bears upon the probative value of that evidence. I'd first cite the case to Yusem versus People, that's Y-U-S-E-M versus People, 210 P. 3rd, 458, a Colorado Supreme Court case from 2009, in which the court noted that the balancing required by Colorado Rule of Evidence 403 contemplates the consideration of such factors as the importance of the fact of consequence for which the evidence is offered, the strength and length of the chain of inferences necessary to establish the fact of consequence, the availability of alternative means of proof, whether the fact of consequence for which the evidence is offered is being disputed, and if appropriate, the potential effectiveness of a limiting instruction in the event of such admission. In addition, Your Honor.
Done. Ms. Nelson, I'm not sure if I'm communicating this clearly. I'm not intending to take additional argument. I just want the authority. I can read the case law. If you want to give me additional case law, I'll take it. I haven't had time yet to read the cases that were cited yesterday, either by you or by Mr. Orman. I am not inclined at this time to take additional argument. I just want to give you an opportunity to cite cases for me, if you wish to do that. Would you like to cite some cases?
Your Honor, I would like to cite some cases, and when I was reading from the case to provide the court with some context for why I was citing the case.
I can read.
I understand that, Your Honor, but I am defense counsel for Mr. Holmes in a capital case, and I am trying to make a supplemental record about an issue that I raised to the court yesterday.
All right. Ms. Nelson, I'm going to say this one last time. I haven't had a chance to read the authority that was cited by the prosecution and by you yesterday. I would like to do that first. I am not intending to have additional argument at this time. If you would like me to review other cases in addition to the one that you cited yesterday, I'll give you an opportunity to do that so that I can review it. We may or may not have additional argument. If you want to make an additional record later, I will give you that opportunity, but not right now. I would like to first read those cases before we move on. So, are there any other cases that you would like for me to read with respect to that issue?
Yes, Your Honor.
Okay. Other than the one that you just cited, 210 Pacific 3rd 458, what else do you have?
People versus McClelland, MC, Cleland, and that's a Colorado Court of Appeals case from January 15th, 2015. And it is such a recent case that I only have the Westlaw site. It is 2015 WL Westlaw 186-962. And I would request, Your Honor, an opportunity to make a supplemental argument when the court has reviewed that authority, because I believe that I made an incomplete record yesterday regarding some constitutional provisions and some of the concerns that we have in this case. So I would request an opportunity to make additional argument at some point after the court has had the opportunity to review this authority.
Okay, no problem. All right, now back to the issue of the pregnancy. Go ahead.
Just a moment. So the way that we view this issue is that there's the issue of the victims who were in the theater who were pregnant, and then the issue of Ms. Mosier, who unfortunately was pregnant and also miscarried.
Let's take the latter issue first.
The issue of the miscarriage, Your Honor?
Yes.
The issue of the miscarriage, I think our argument, it goes back to the argument that we were making yesterday with respect to the what is probative about these injuries to the counts that are charged in the indictment. As I mentioned to the court yesterday, we concede based on the case law that limited and brief testimony about the nature of the injuries can be construed as some circumstantial evidence, potentially, of intent. But the issue of a miscarriage, while a very tragic injury, Your Honor, is somewhat different, especially in a case where there's no evidence that the defendant had any knowledge whatsoever that any of these victims in the theater were pregnant, and there's no evidence whatsoever that there was an intention to harm the unborn child, certainly. Especially here, unfortunately, there were other serious physical injuries that Ms. Mosier suffered that may be admissible as potentially probative in some circumstantial way of state of mind. But because of the nature of the miscarriage, that argument just doesn't apply. The rationale for why injuries are relevant to the attempted murder counts. Just, it doesn't apply in the same way to the issue of a miscarriage.
You said that this was a tragic injury, and so do you concede that this constitutes an injury?
I was not able to find any case law directly on that point, Your Honor.
Well, what did you mean when you said this was a tragic injury?
Well, it's a very tragic situation.
But you said this was a tragic injury.
It was a loss that Ms. Mosier suffered.
When you said a tragic injury, were you referring to Ms. Mosier?
I was referring to Ms. Mosier, Your Honor. Now, the issue of whether or not it's an injury, I'm not sure that.
Well, you said this was a tragic
Well,
injury.
Your
a
Honor,
moment ago.
I understand what I said, and I'm now trying to explain myself. I'm sorry if I was inartful. The issue is, serious bodily injury, again, is not an element of attempted murder. And so, whether it fits the legal definition of an injury or not, the question is whether this evidence can fairly be seen as potentially probative in some way of state of mind. And because of the nature of the relevant circumstances in this case and the fact that there's no evidence whatsoever that Mr. Holmes was aware that any of these victims in the theater were expecting babies,
Well, you admitted,
it's not probative in the same way.
You
So
admit-
whether or not it's an injury,
you
it's not
admitted a moment
probative.
ago that brief evidence of injury is admissible. And so it seems to me, the first question I have to decide is, was this an injury? When a woman is shot, and as a result of that shooting or being shot, she loses a pregnancy, is that an injury? Was she injured?
well, I think that our position is taking a step back, that it's evidence, whether it's evidence of an injury or some other kind of evidence. The question with respect to all evidence is whether that evidence is relevant to a material issue in the case, whether it makes a material fact in the case more probable or less probable. So whether it's construed as an injury, whether it's construed as a tragic loss, however you want to interpret whatever a miscarriage is, which is, it's very, very tragic what happened here. However you construe it, the question is not ultimately whether it's an injury, the question is whether it can fairly be considered as circumstantial evidence of intent. Our argument is that given the facts of this case, it can't. And it's prejudicial for obvious reasons and has very little probative value. That's our argument.
So is your position that this is an injury or not? Is this
We're
an
not
injury?
taking a position necessarily on whether it is an injury. We're taking a position about the probative value versus the prejudicial effect of this proffered evidence.
You said that Ms. Mosher suffered other injuries, and I infer from what you were saying that you meant that the prosecution can present evidence of those other things, those other injuries, and they don't need or they don't have to present evidence of the pregnancy. Is that what you were saying?
Yes.
That because she has other injuries, then the evidence of the pregnancy is then inadmissible?
Well, those other injuries are probative. We're making a distinction between the injuries in terms of their probative value. So, yes, the probative value of the other injuries that she suffered are similar to the probative value of other injuries of surviving victims in the case. But our argument is that evidence of a miscarriage is different.
So you think that because she suffered other serious injuries, then evidence of the pregnancy, the termination of the pregnancy is inadmissible?
Well, we think that it goes to the 401, 403 analysis, Your Honor.
Well, what if
It
she-
goes to how much how much probative value that evidence has then, in light of the other evidence that's available to prove the counts that are charged in the indictment.
What if she hadn't incurred any other injuries? What if the only thing that happened to her, and the only thing sounds like this is not a big thing, and obviously any termination of pregnancy is, but what if that's all there was, is the termination of pregnancy? then in that case, would it be inadmissible?
I don't know, Your Honor. I think it would depend on the facts. Those aren't the facts that are before us.
Okay. Thank you. Who wants to respond on behalf of the people?
Your Honor, and at this stage, do you still just want us to talk about the miscarriage and not pregnancy in general?
Yes.
Okay. So the people's argument, Your Honor, is that, if you ask a million mothers are going to tell you that a gunshot causing a miscarriage is an injury. You asked Ashley Mosier, who's lost everything in her life, her 6-year-old's murdered, she's paralyzed, and she had a miscarriage, she can't have children ever again. It's a substantial injury. And it's important to her to get to testify about that. And it's important to the people when we're trying to prove both attempted murder after deliberation and attempted extreme indifference murder, that these are circumstances that evidence complete indifference to human life. There was evidence presented today that the defendant was in that theater and walking around the theater while observing the patrons of that theater. Katie Medley testified that she was 9 months pregnant. I think there is circumstantial evidence that the defendant could have observed pregnant women. In fact, 4 of our injured victims were pregnant in this case, not to mention other patrons of the movie theater. I think it's a fact of this case that several victims were pregnant, including Ashley Mosier, and frankly, in like the Paul's graph sense of the word, Your Honor, the defendant is the proximate cause of those injuries, and there's no intervening cause. And I think also in a different sense of like an eggshell plaintiff sense, you take your victims as you find them. You take your victims if they're elderly. You take your victims if they're well, and you take your victims if they're pregnant. And I think that also, potentially, in certain cases, the fact that you're pregnant can exacerbate your condition, and potentially you're also more at risk at that point of death. And these are attempted murder counts that we're trying to prove in this case. So we would argue that, in fact, this is evidence of injury. It's extraordinarily probative in this case, and it's not substantially outweighed by the danger of unfair prejudice when the jury is going to hear that this woman's 6-year-old daughter was murdered. That's certainly a more prejudicial fact than her miscarriage, even though they're both tragic.
What other injuries did she suffer?
She's paralyzed, and she was shot, and she will testify about all that, and she also has extreme nerve damage and is in pain every day.
What about the argument that these other injuries that are serious make the evidence of the pregnancy being terminated inadmissible under 403?
And I don't see any authority for that. I haven't read any cases that say that that's true. Frankly, Mr. Nolan testified, and how do you judge which one is more unfairly prejudicial? The arm that has a graph of a tattoo on it, or the leg that's half shot off? They're both horrific, and I don't think one is more unfairly prejudicial than the other.
What about the rest of the women who were there who were pregnant? How many of them were there?
Well, I don't know total, Your Honor, because all victims never contacted us in this case, but 4 victims who will testify in this case were pregnant at the time of the shooting.
And why is that probative? Why is it relevant that they were pregnant if they did not suffer any injury related to the pregnancy?
And, Your Honor, I think the court made a good distinction at the bench yesterday, and I think that that's a distinction that the people think is important for the court to look at. There's, frankly, 2 Colorado cases on point, Your Honor. I don't know if the court already found those, but one is People v. Manier, which is M-A-N-I-E-R, 518 P. 2nd, 811, Colorado 1974 case. And that case says that in that case, it was okay to talk about the victim's pregnancy because it was res justi in that case, because the prosecution's theory that the defendant in that case was motivated by the fact that that victim was married to another man and was carrying that man's child. There's another case that's distinguishable, which is a Colorado Court of Appeals case from 1986, People v. Martinez, which is 734 P. 2nd, 650 at 652. And in that case, the Colorado Court of Appeals said that the trial court erred in admitting evidence that the victim was pregnant and was 5 months pregnant at that time because the defendant didn't have knowledge. The court found that it was harmless error, but error nonetheless. So I think the distinction that the courts in Colorado are looking at is that is the fact of pregnancy relevant to somehow show why a witness acted the way they did. So for instance, when the court ruled the other day about Ms. Bailey's testimony, the court made the distinction that that's why she was babysitting this person at this time, because Ms. Mosier needed to go out and have an ultrasound that day, and that's why she was babysitting. Similarly, I think Ms. Medley's testimony yesterday was relevant because she explained why she had to abandon her husband in the movie theater, because at that point in time, she thought it was more important to save the one thing she had left, her 9-month-old baby at the time. And so I think that it's important for the prosecution to make those distinctions. And I also think that, perhaps it also may be relevant to explain why a witness acted the way they did at the time. Just like a mother would dive over their child to protect them, so would they do the same to protect their unborn child. So I think that if the prosecution can make an offer of proof to the court that it is relevant to the testimony of why the victim acted the way they did at the time, then we would ask that that evidence be admissible in this case, and I think that's consistent with the case law of both Martinez and Minier.
Well, with respect to women who were pregnant, other than Ms. Mosier, I intend to continue to proceed the way I did before, and that is there has to be some probative value to the evidence, otherwise it's inadmissible. You can't just bring it up, and witnesses can't just bring it up, and so you need to talk to your witnesses and make sure that they don't mention that unless you have raised that issue with the court outside the presence of the jury, and you've made an offer of proof, and I have ruled after listening to both sides that it is admissible. There has to be probative value, so it has to be admissible under 401 and 402, and then it has to be admissible under Rule 403, meaning that the probative value of the evidence can't be substantially outweighed by the danger of unfair prejudice or by any of the concerns that are listed in Rule 403. Including cumulative evidence, including confusion of the issues, including all the other concerns in Rule 403. With respect to Ms. Mosier, I've thought a lot about this, and I agree with the people. I think it's an injury, and I think it's admissible. It's probative. It is a serious injury. I think Ms. Nelson called it a tragic injury initially, although she later, I think, backed away from that. I do think it is a tragic injury, and I think that the fact that she had other serious injuries doesn't make it any less probative. I don't see how that makes it any less relevant, and I don't see how that makes it any less admissible under Rule 403. And if Ms. Mosier had been more fortunate and had only lost her pregnancy and had not suffered the other serious injuries that she suffered, it would still be admissible. We would not be in a position where we would be saying, well, she lost her pregnancy and that's not an injury to her, so the prosecution cannot present any evidence of injury related to her. I think that evidence of injury in this case is relevant to the charges that have been filed, specifically the types of attempted murder charges that have been filed. The prosecution has filed two types of attempted first-degree murder. One type alleges that the defendant took a substantial step toward the commission of murder in the first degree after deliberation and with intent, and murder in the first degree after deliberation and with intent alleges that the defendant unlawfully, feloniously, after deliberation and with the intent to cause the death of a person other than himself, caused the death of a particular victim. In this case, it would be Ms. Mosier. Of course, he is charged with attempt to murder Ms. Mosier. The other type of charge that has been filed by the prosecution with respect to Ms. Mosier is attempted first-degree murder, extreme indifference. And that charge alleges that the defendant took a substantial step toward the commission of the crime of first-degree murder, extreme indifference. And the crime of first-degree murder, extreme indifference, involves an allegation that the defendant unlawfully and feloniously, under circumstances evidencing an attitude of universal malice, manifesting extreme indifference to the value of human life generally, knowingly engaged in conduct which caused a grave risk of death to persons other than himself, and thereby caused the death of, in this case, the name of the victim would be Ms. Mosier. Again, he's charged with attempted murder with respect to her. So I think given those elements, I think evidence of injury is very relevant. Is it prejudicial? Yes, it's prejudicial, but it's not unfairly prejudicial. And certainly the danger for unfair prejudice does not substantially outweigh the probative value of the evidence. This is no different than other serious injuries that other victims have sustained. And if the defense wants me to consider giving some kind of limiting instruction to make sure the jury understands that the fetus is not the subject of a homicide count, or that it's not the subject of any charge in this case, I'm happy to entertain it, to at least consider it. That's not what the prosecution is intending to introduce this evidence for. They're introducing it for purposes of proving the two attempted murder charges that relate to Ms. Mosher. And not only does the evidence go to the elements of those charges, the evidence is also relevant with respect to the circumstances surrounding the shooting, the circumstances surrounding what took place allegedly here. And part of what it is alleged to have taken place and have resulted from the shooting is these injuries that these folks sustained. And I think that's part of the case that the prosecution is entitled to present. Again, there has to be some limits to the evidence, and I have discussed that. And yesterday I stopped Mr. Weaver when he started talking about how, as a result of his injuries, he got depressed, he gained weight, and there were other consequences. And I determined that that went too far, and I stopped him. And I stopped him because that went beyond what I think the law allows in terms of injuries that are caused by the shooting. And the fact that serious bodily injury is not an element doesn't mean that all of this evidence is inadmissible. The fact that the defendant is not contesting this evidence doesn't mean that it's rendered inadmissible. Again, the people are not required to accept an offer of a stipulation. Also, the fact that the defendant may not have known that Ms. Mosher was pregnant does not render the evidence inadmissible. This is not a tort case. This is not a personal injury civil action in which the prosecution has to prove some kind of foreseeable element. There's no foreseeability requirement. And so just because he may not have known that Ms. Mosher was pregnant doesn't mean that that injury is rendered inadmissible. So for all those reasons, I find that evidence related to the termination of the pregnancy of Ms. Mosher is admissible under 401, 402, and 403. All right, I'm going to take under advisement the other issues with respect to the jail log records and with respect to also the victim impact videos. Is there anything else at this time on behalf of the people?
Your Honor, I just wanted to clarify if the people have the court's permission to submit those redacted videos to the court tomorrow by noon.
I said yes.
Okay, and is there a way the court would prefer that we label that pleading or anything? I mean, I'm not going to write anything, but just to give you the...
You can just mark them as an exhibit in support of the, or in response to the oral motion to exclude victim impact evidence made in open court on April 30, 2015. I think Ms. Nelson marked the CD that she gave me as exhibits A to H, A as in letter A as in apple, through H in support of oral motion to exclude victim impact videos made in open court on April 30, 2015. So you can mark it similarly.
Thank you, Your Honor. And Mr. Orman just told me that I should make my life easier and ask for the end of the day with the court's permission instead of noon.
Whatever, the sooner the better. So I'm not going to place a deadline on it, but, we'll be in trial again on Monday. So I don't have to rule on this right away, and I may very well wait on that issue. I probably will try to address the jail log issue first. All right? Is there anything else on behalf of the defense at this time?
No, Judge.
All right, and Ms. Nelson, you need to remind me to give you an opportunity to make that record that you mentioned with respect to injuries after I have reviewed the authority that was provided. All right, thank you, folks. The court will be in recess. Have a good weekend.